Hey everybody, Paul Rabelais here. This is the big one. This is the big live stream, maybe the one you've been waiting for. It is a big topic, and we're going to cover a lot of information. So it's all about protect your home and life savings from nursing home expenses. Okay, so let's just jump right in. A couple of quick ground rules are if you have some questions, some comments, some experiences you would like to share, the chat is the perfect place to put it. So I'm going to be painting with a broad brush for reasons I'm going to tell you here in a moment. But if you have any particular situations, maybe something in your state, maybe a unique situation with your family, and you want to share that, feel free to do it in the chat. I'm going to let you know now that when I finish my presenting of information, and then I go take a look at the chat, there's likely to be a number of questions in the chat. I'm going to tell you now, I'm going to take a pass on some of the questions because we're painting with a broad brush in this presentation. We're really talking about rules that apply to just about everyone. But Medicaid is a kind of combined federal and state program. States have some leeway, and so states often take that leeway and create particular rules that aren't consistent with other states. So I don't want to get anything wrong. In fact, I do want to let you know that, don't take any action, don't take any major action, or don't take any action based solely on the information presented in this YouTube live stream. Make sure you get the advice of an attorney. I want to kind of have that disclaimer. All right, so the way we're going to approach this, got a lot to cover. I want to give you the background, and then I want to share with you the main rules that apply. And then third, I want to talk about some of the planning strategies that people can take advantage of to protect what they have if that's their desire. But before we get into all the rules and all the planning strategies, I feel inclined to give you some background. So like I mentioned, Medicaid, what we're talking about here, quite frankly, is and bluntly, is if I can be as blunt as I can get, Medicaid planning involves making yourself appear destitute so that the government pays for your long-term care, typically in a nursing home. And so you don't have to pay for the nursing home out of your own pocket. Nursing home costs costs can vary. The subject of nursing home costs, monthly cost of a nursing home, is a great subject for the chat. I'm guessing of those of you who are on the live stream right now, you may have some experience with parents or spouses or other loved ones. If a nursing home, if you're 100% aware of what a monthly nursing home expense is for someone in your area, throw it in the chat, because it varies depending upon where you are in the country and other factors. But you could be anywhere from maybe $6,000 or $7,000 a month on the low end to maybe $16,000 to $18,000 a month on the high end. Again, throw your experience in the chat. So the whole idea of protecting assets from the nursing home, the whole idea of this Medicaid long-term care, Medicaid eligibility planning is really all about making yourself appear destitute under the Medicaid eligibility rules. So you don't have to pay for the care, the government pays for the care. And so with that background, I do want to say clearly that Medicaid planning is not for everyone. By no means should everyone run out and take advantage or attempt to take advantage of some of the planning strategies when we get to that in just a little bit in this live stream. So let me give you some reasons why, at least in my humble opinion, why Medicaid planning and making yourself appear destitute in the government's eyes so they pay for your nursing home instead of you paying for your nursing home. Let me give you some specific situations where Medicaid planning just isn't for everyone. Well, one is you have significant assets of your own. If you're sitting on $2 million, $3 million, $5 million of assets, at least in my view, Medicaid planning is not for you. You're fortunate that you have the resources, whether those resources of yours are in a retirement account or in your bank account or in your brokerage account. If you have an estate of 2, 3, 4, 5 million, you probably also have some income, and so the idea there is, again, there's exception to every rule, but if you're fortunate to have several $1,000,000 of assets, kind of your mindset should be, if I get to a point where I need long-term care services in the future, you know what? I'm gonna take care of that expense out of my own pocket, and I'm gonna get the kind of care that I deserve to get. I've worked hard to accumulate what I have. I know that the kind of care that the government provides to the destitute, to the people with less than $2,000 in their name, that care is not the greatest. So I'm going to forget about trying to qualify for Medicaid by having less than $2,000 in my name. I have a few $1,000,000. I'll take care of that expense myself. Let's forget about Medicaid planning. So Medicaid planning is not for the wealthy, and I know wealthy needs to be a defined term, but I talked a little bit about a few $1,000,000. Also, if you have significant income, there are people out there when you add together all of their pension income, their Social Security income, perhaps they have rental properties and have rental property income. Maybe they're even still working a little bit, and they have RMDs, required distributions from their IRA. So they have income, and they have more than enough income than they need. And if they go into a nursing home, they can use that income toward their care without having to dip into their nest egg or their principal. Well, maybe that individual or that married couple is not a candidate for Medicaid planning as well. Another area where Medicaid planning may not be appropriate is you don't want to lose control over your assets. For some people, no big deal. For some people, a big deal. So most of the pre-planning Medicaid eligibility planning involves transferring assets out of your name, and there's definitions for what is out of your name, but generally it's out of your name means out of your control, where if you want to spend those assets, at a minimum you've got to get permission from someone else to spend them. So if you don't like the idea of losing control of what you have, maybe Medicaid planning is not for you. Also, Medicaid planning is not for those. There are people who I've talked to have said, you know what, maybe I'll talk to a couple and their daughter, and between the three of them together, in particular the daughter may chime in and say, you know what, Mr. Rabelais, there is no way I'm ever going to permit my parents to live in a nursing home. I'll build out a separate wing onto my house. I'll bring in all the care that they need, but they're never going to go into a nursing home. I'll make sure that they'll either live in my home or the daughter may say, there's no way I'm going to let my parents live in a nursing home. So if that's true, then why even go to the trouble of getting assets out of your name in order to qualify for a government program that pays for people's nursing home expenses? All right. And then another one is you shouldn't engage in Medicaid planning, which typically involves getting assets out of your name and transferring assets out of your name if you'd already qualify for it without having to do anything. We'll talk in a little bit about how maybe couples who have maybe only $100,000 in assets to their name and one of them is going into the nursing home. There's a likelihood that one who's going into the nursing home is going to qualify anyway for reasons that we'll talk about in a minute when we talk about the rules. So don't do these transfers if you would already qualify for Medicaid by doing nothing. Another big issue, and feel free to throw your opinions in the chat on this one, but it's not uncommon to have this ethical concern about taking assets that you have and repositioning them for the sole purpose of making yourself appear destitute to the government. Now, the rules say you can do it, and perhaps if the government didn't want you to be able to do this, the government should change the rules. We'll talk about that later. But some people feel, and I'm not one to argue with them at all, that, hey, if you have $1 million in the bank, in your nest egg, in your savings, really, some people feel like, you know what, you should use those assets toward your care. Don't put that expense on the taxpayers. Taxpayers have enough expenses already. So there is that ethical concern about Medicaid planning. Also, in many states, if you have an IRA and it's large, in order to get that out of your name, you've got to take income taxable distributions out of that IRA, significant income tax expense, and then transfer those after income tax expense proceeds out of your name. So sometimes there's a big income tax cost in order to engage in Medicaid planning. Be aware of that. We'll talk in a little bit about, just a couple more here, a little bit about the 5-year look back period. So some people will talk to me, maybe a son will talk to me about his father. And everybody knows, if it's not said explicitly, it's kind of said under the radar indirectly. Son may say, you know, my dad's going into the nursing home tomorrow. And you know what, Paul, doctors say he has, about 6 months to live. Well, why engage in all of these transfers when at best dad would qualify for Medicaid 5 years later? So if you don't have 5 years, and who knows, there have been miracles and people have lived a lot longer or a lot less than what the doctors predicted, because it's not an exact science. But if you don't have 5 years, don't make this elderly person go through a bunch of meetings and signatures and legal documents when a person just really will never, ever get that benefit of Medicaid. So last point here, get off my soapbox and we'll just hammer into the rules and the planning strategies. But my last point here is, I think some people assume that, let's do this Medicaid planning because, if I can get the government care, great. I don't have to pay for it. If I have to pay for it, that's terrible. However, most people feel like, and back me up in the chat here if you'd like, nursing home care is poor. And generally speaking, all Medicaid is for is nursing home care, not assisted living. That's different. Skilled nursing home care. They don't pay for care for somebody to come in your home and take care of you. So you almost have to prepare yourself. If you're going to do this Medicaid planning, you're going to get a poor level of care. Again, the kind of care the government provides for people who have less than $2,000 in their name. So for that reason, some people don't engage in the Medicaid planning because they just don't want to put themselves in that position. Okay, so let's go the other way. Who might Medicaid planning be for? So again, there's no hard and fast rules here, but maybe someone has a modest home. What is a modest home? Maybe it's worth $300,000 or $400,000. Maybe someone has a modest savings. Maybe they've worked hard and saved their whole lifetime, and they have a couple $100,000 of savings. And maybe their heirs have certain needs. Their heirs are down on their luck. Their children are ill, and it's really critical in order to provide for the children after the parents pass away that those parents figure out a way to protect those assets so that they can be for the children down the road, because the children aren't going to get any help from anywhere else. So that's just an example of who might Medicaid planning be for, but there's no hard and fast rules. All right, so we got Janet D saying $16,000 in Connecticut. Speak from experience. That's the kind of chat I'm looking for. Thank you for the information, Janet D. All right, and Medicaid care very, very bad in Illinois. Thanks for backing me up on that. Kids living at home, and I think I can't see the whole thing there. All right, so now it's time for part 2 of this 3-part live stream presentation. Part 2 is, what are the rules? And part 3 will be the planning strategies that people often take advantage of. So this is for that individual, that couple. Maybe they're 65 years old, maybe they're 70 years old. Maybe they've seen their parents go through a skilled nursing home care, situation, and that 65-year-old person or couple is like, geez, what my parents just went through, is there anything we can do to avoid whatever situation the parents may have gone through? How can we protect what we have? Okay, so let's jump right in. So the way I'm going to go over the rules is this way. When someone is, we'll call it on the doorstep of the nursing home, or they're entering the nursing home. Let's call it an 80-year-old, and they broke their hip, and they need to go into a nursing home facility, and they're going to be there probably for the long haul, whatever that long haul might be. That person needs to consider whether to apply for Medicaid, and they'll make that decision on whether to apply for Medicaid based on whether they think they're going to qualify for Medicaid. It doesn't do much good to apply for Medicaid if you're just not going to qualify. A couple of exceptions to that, but you typically apply when you feel like you're going to qualify. How do you qualify for Medicaid? Well, the application process involves revealing lots and lots of financial information, asset information. What do you own? What are debts that you have, if any? What income do you have? What's your medical condition? So the application process is thorough. Now let's stick to the assets for now. When someone enters a nursing home and they've completed a Medicaid application, Medicaid's going to look at their assets. Generally speaking, there's what I call, for Medicaid purposes, two kinds of assets. There are exempt assets, and there are what's called countable assets or countable resources. So the assets that are what's called exempt, Medicaid doesn't look at these assets for purposes of determining Medicaid eligibility. There's a bunch of them, but the main two are your home and a vehicle. Now, how valuable is your home may be a factor in your state. In many states, a home that is valued in 2024 at less than $713,000 is an exempt asset. If it's valued at more than $713,000 or whatever that applicable amount is in your state, then you've got a problem. The additional amount is not exempt. And then they allow individuals or couples to have a vehicle as well. All right. And so those are the exempt assets. So let's say grandpa's going into the nursing home. He has a $500,000 house and he has a $25,000 car. You disclose it, but Medicaid says it's okay so far. He can have the house, he can have the car. But then they also look at what's called the countable resources, which essentially is everything else. Your bank accounts, your investments, depending on the state, your retirement account, your IRAs, your 401ks, the cash value of your life insurance policies that you own, annuities that you own, real estate that you own that's not your home, rental property, an interest in a business. Maybe you own part of or all of an LLC or an S corporation. Maybe you have some publicly traded stock. All of those are countable resources. And then there's three standards for these countable resources, how much you can have and qualify for Medicaid. If you're a single person, unmarried single person, dad's going into the nursing home, he'll qualify for Medicaid if his countable resources at the time he applies are less than $2,000. A married couple, if both spouses are going into the nursing home together, and again, this number might change from state to state, but it at least is going to give you an idea. Married couple, if both are going to the nursing home instead of one of them, we'll get to that next. Married couple with both spouses in the nursing home, their countable resource limit is $3,000. And then you've got the married couple situation where one of them goes into the nursing home. That's called the institutionalized spouse because they're going to be in the institution. And then you've got one spouse who's called the community spouse because they're still living in the community. It has nothing to do with community property. It has everything to do with they're living in the community. So If you have a married couple, one spouse in the nursing home, one spouse still living at home, for example, that married couple can have countable resources of up to 2024 number, $154,140. The rationale is the spouse who's still living at home got to have something to live off of while the other spouse is in the nursing home. Okay, so let's take an example. Dad is single. He has his $500,000 house. He has his $25,000 car, and he has $200,000 in the bank. He's single. His $200,000 in the bank is going to render him ineligible for Medicaid, and because he's single and he has more than $2,000 of countable resources. Some people will say, well, Paul, does that mean Medicaid's going to go take his bank account? Are they going to take his car? Are they going to take his house? Are they going to go to his bank and say they're coming from the government and the bank's going to turn over their money to him? The bank never goes and takes your money. They're just going to say, hey, dude, you're ineligible. If you're going to stay in this nursing home, you need to pay us $12,000 a month. In Connecticut, $16,000 a month. So someone fills out a Medicaid application. If they qualify, Medicaid covers the expense. If they don't qualify, either they've got to leave or somebody's got to come up with the monthly nursing home expense. Okay, so and let's keep going with the rules here. Let's change it up a little bit. Let's say when Dad goes into the nursing home, he has his $500,000 house, no problem. It's worth less than $713,000. He has his $25,000 car, no problem. Vehicles is an exempt asset. But let's say he only has $1,000 of countable resources. He's got $1,000 in the bank. He's going to, assuming he didn't make any transfers, we'll get to transfers in a minute, but let's say he in the last 5 years, he hadn't transferred anything out of his name. Just normal course of events, got his house, got his car, he's got $1,000. So he's going to qualify for Medicaid. However, what you need to be aware of is generally speaking, the estate recovery rules. Remember, we said he can have a house and he can have a car, and those are exempt assets, but they're not really completely exempt. You see, once Dad goes into the nursing home, he qualified because he had less than $2,000 of countable resources. He only had $1,000. But when Dad dies, you see, Medicaid has these estate recovery rights. So Dad's in the nursing home. He's still got his home. He's still got his car, and Medicaid pays for his nursing home for years. And then when he dies, well, Medicaid has these estate recovery rights. Generally meaning Medicaid's going to tell the surviving family members, and I'm pulling this number out of thin air, hey, estate of Dad, or hey, heirs of Dad, while Dad was in the nursing home, Dad spent $400,000 of Medicaid's funds. Medicaid has a lien on Dad's estate, so you're going to have to sell Dad's home, pay us back the $400,000 that we spent, or that the government spent while Dad was in the nursing home, and then the heirs can get what's left. So that's estate recovery. What you have to remember is even though certain assets are exempt and they're not counted for purposes of initial Medicaid eligibility, they are subject to the government's estate recovery rights down the road when that nursing home resident passes away. Okay, so that ought to start giving you some idea of what you can have, what you can't have, estate recovery. Next, let's go into what the rules are on transfers, because you might think, well, hey, Dad, he's fixing to go into the nursing home. He's got his house, he's got a car, he's got a couple $100,000 in the bank, and that's a problem because he can only have $2,000. So no problem. Let's just get Dad to move all of his bank account into the kids' names and have the kids now as the owners of that money. Dad won't have more than $2,000 of countable resources. Well, I say the government probably caught that one pretty early on. So what they do is they penalize people for transferring assets out of their name. So when someone applies for Medicaid, not only do they have to disclose all of their assets, not only do they have to disclose all of their income, and again, the government has lots of different ways. Don't have as your Medicaid plan, we're going to lie on the Medicaid application and commit Medicaid fraud. Number one, it's Medicaid fraud. Number two, you're likely to get caught because of all the supporting information that you have to provide. And if there's a safe deposit box, Medicaid can get into it, and lots of other ways Medicaid can verify information. So, but when you apply for Medicaid, Medicaid's going to ask, hey, have you or has dad made any transfers of any assets out of his name? They're probably going to ask you, has dad made any transfers of assets out of his name in the last 5 years? If you can say, no, dad has his house, his car, and he has $1,000 in the bank, and he hadn't transferred anything out of his name, or hasn't made any what Medicaid calls uncompensated transfers, where he transferred money to someone and got nothing in return. So if the answer is no, great, dad's eligible for Medicaid, and Medicaid will start covering the nursing home expense. But if, however, on the Medicaid application, we're filling it out, dad has his house, dad has his car, dad has $1,000 in the bank, and here's this next question: has dad transferred anything out of his name in the last 5 years? Well, 18 months ago, dad transferred $175,000 out of his bank account, and he put it in his son's name and in his son's bank account. So what that does is that triggers a penalty period. And I don't want to get too deep into the penalty period calculations, but I am just going to, for starters, say that typically you don't even want to apply for Medicaid until 5 years after the last transfer was made. So if you're saying, yeah, dad gave away $175,000 4 years ago, because of the way those transfers are penalized, don't apply for Medicaid. Just let that 5-year period lapse. So dad transferred $175,000 4 years ago. You don't apply for Medicaid because he's not going to qualify because he made a transfer of his assets within the previous 5 years. So what you do is you just don't apply. You just use those funds, assuming they're still around. Maybe the funds are in the son's bank account. You use those funds to get dad through the last year of this 5-year look back period, and then apply when you're in a position where you can answer no to the question, has dad transferred any assets out of his name in the last 5 years or the last 60 months? Well, he transferred $175,000 5 years and 2 months ago, and but no, nothing in the last 5 years. And so there is a whole timing of the Medicaid application process that's real important. But all right, so some people, upon hearing that there are penalties for potential Medicaid applicants making transfers, will ask the question, well, Paul, I heard that you can make transfers or donations of what next year is $18,000, was this year $17,000. Paul, I heard that you can donate $18,000 to as many people as you want to every year, no problem. Well, no problem from a gift and estate tax perspective, but big problem for Medicaid application purposes. So this, what is now what's about to be $18,000 federal gift tax annual exclusion amount that the wealthy people utilize to get assets out of their estate and have them avoid the 40% federal estate tax when they die. That's purely a tax mechanism. That has nothing to do with Medicaid. So if dad applies for Medicaid and has dad made any transfers out of his name in the last 5 years? Well, every year he gives his kids and grandkids $18,000, but that's within the limit, so that's okay. And you know what? It's not okay for Medicaid application purposes. That's going to cause some big time ineligibility periods. So just be aware that the $18,000 gift tax annual exclusion is applicable for taxes, but not for Medicaid. All right. Now, There's your basic set of rules, very basic set of rules. Let's just kind of recap that. When someone applies for Medicaid, they fill out a Medicaid application, and Medicaid's going to say, great, you qualify, come on in, we'll pay for your care. Or Medicaid's going to say, you don't qualify based on some answers on your application. If you're going to stay here, you need to pay the applicable monthly rate. And so when someone applies, they typically often have some exempt assets. The main ones are the home and the car, and the home is exempt if it's up to $713,000 in value. And then people typically have some countable resources, but there's some limits on how many countable resources that they have. If they're single, 2,000, married and both spouses going in the nursing home, 3,000, married, one spouse going into the nursing home, that married couple can have, depends on your state, but many states say $154,140. There's the estate recovery rules that say, yeah, your home is not an asset for purposes of Medicaid eligibility, but when that homeowner and Medicaid recipient dies, the state can force its estate recovery rights. Many states are required to enforce their estate recovery rights. In essence, that requires that the estate sell the home, reimburse Medicaid for what it paid. The rest stays in the estate to be distributed to the heirs. There's penalties when you transfer assets out of your name. We're going to talk about that more in a minute. And the $18,000 gift tax annual exclusion doesn't have anything to do with Medicaid. Okay. Now, we'll go into really the final part of our live stream here is what are some of the planning strategies? So there's really two kinds of planning strategies. We're not going to talk too much about what people call the crisis planning, which is, oh my God, mom broke her hip. Never in a million years did we think she'd need long-term care. She broke her hip. She's been in the hospital. They're telling us she's got to go from the hospital to the nursing home. Nursing home's going to cost $12,000 a month. Never did we think this would happen. What do we do? So that's crisis planning, where you don't have any time. And we're not going to talk too much about crisis planning, but some of it involves transferring countable resources into exempt assets. So, maybe they make improvements to the home, which is an exempt asset, although it's subject to estate recovery down the road. So we're not going to talk too much about crisis planning, because oftentimes there's just not much you can do if you're on the doorstep. The rules are designed where if you have assets, you're supposed to pay for your care. So there are some crisis planning strategies, but this real live stream is more about the pre-planning. You're not going into the nursing home tomorrow. You certainly don't even expect to go in next month or next year, but down the road, it's a possibility. So what's some of that pre-planning? Well, pre-planning generally involves transferring the assets out of your name and then surviving the 5-year look-back period. So someone transfers, they're 72 years old today. They transfer their $400,000 savings account out of their name, and then they go into a nursing home 6 years later when they're 78 years old. Well, that $400,000, if everything was done right, is going to be, as they say, protected, because if they go into a nursing home when they're 78 and they're asked on a Medicaid application, have you transferred any assets out of your name in the last 5 years? The answer is no, because you would transfer $400,000 out of your name 6 years earlier, no problem there. So that's pre-planning. The gist of it is transferring assets out of your name and then letting the 5-year look-back period expire, and then those assets are protected. Okay, so when we say transfer assets out of your name, what does that mean? So there's definitions for that. Some people think, well, let me just put all these assets in my kid's name. So I've got a house. I don't want it to be subject to estate recovery when I die, so I want to get that out of my name. I've got a $400,000 savings account. I want to get that out of my name, so I'm going to put that in my kid's name. I own some stock, and so let me get that out of my name and just put it in my kids' names. So some people do that. Easy to do. Now, there's some reasons why many people who engage in Medicaid pre-planning, they don't just take what they have and just throw it into their kids' names. Probably the big one is you lose control over that asset just by putting it all in your children's names. Never know what your children might do with it. Might have the perfect family. They might just set it aside, and if you need it, they'll give it back to you, or they'll spend it on you, or they might not do that. So, and there's some tax disadvantages, mainly losing the Section 121 exclusion on the sale of a residence. If you put your home into your kids' names and then they sell it, you will have lost that opportunity to exempt $250,000 of capital gain from the capital gains tax, or if you're married, $500,000 of gain from the capital gains tax, because you don't own that home anymore. That home belongs to your children, but they're not living there, so that exclusion is not available. Another disadvantage of transferring appreciated stock, for example, just putting it in your kids' names, is by giving it to them during your lifetime, they get what's called a carryover basis. If you happened to buy some Apple stock years ago when it was worth $10 a share, and today it's worth $195 a share, if you give that stock or transfer it into your children's names, then they'll get what's called a carryover basis. Their basis, when they sell it one day, will be the $10 basis that your basis was. Your basis carries over to them. So when they sell it, whenever they sell it, before or after your death, there'll be a significant amount of capital gain that will be subject to capital gains tax. So those are some disadvantages of just transferring your assets to your kids. So what a lot of people do is transfer assets to a particular type of trust in order to retain some control over those assets after they're transferred, and to gain some of the tax advantages of the step up in basis and the preservation of the $250,000 or $500,000 exemption from capital gains tax if the residence is sold. All right, so let's touch on that for a second, on the transfers to a trust. Some people mistakenly believe that if they have a revocable living trust, a lot of estate planning involves transferring assets to your revocable living trust in order to avoid the court and attorney involved probate process when you pass away. Some people mistakenly tell me, Paul, no problem. We've moved our assets to a trust already. A few years ago, we set up a revocable living trust. I'm the trustee. They say I'm the beneficiary. I can do whatever I want to with those assets, but the assets are in a trust. So that's great. They're protected from long-term care expenses. I'll be eligible for Medicaid, right, Paul? Big fat no on that one. So in every state, assets that are in your revocable living trust are considered a countable resource for Medicaid eligibility purposes. Some people mistakenly say, well, if you put your assets in a revocable with an R, living trust, doesn't work for Medicaid. But if you put your assets in a irrevocable trust, no problem. That's not exactly right either. It has to be a particular type of irrevocable trust. Let's start with this. Many people, in order to start the 5-year look-back period, they put their assets into a trust just to have maybe continued ongoing management by the same person, instead of dividing up your $400,000 and giving each child $100,000. Perhaps you put that into a trust. Perhaps name one of the children as the trustee, because that trustee that you named is going to hold on to it until you pass away, and then they're going to disperse it to the beneficiaries. So, but my point here is not just any irrevocable trust does the job. Let's start with the fact that in every state, it has to be not only an irrevocable trust, but the trust has to provide that under no circumstances whatever can you go get the principal out of that trust and put it back in your name, or at no point can any of the principal even be available for you. So what you're doing is you're kind of parking assets in a trust that you can't get back on your own, or you can't spend on yourself or by yourself. those assets are kind of parked in an irrevocable trust. Yeah, they'll go to your heirs or beneficiaries when you die. And some people look at the fact that oftentimes when dad has four kids, he puts his $400,000 of assets into this irrevocable trust, maybe names the oldest child as the trustee. And perhaps that trustee has the ability to make distributions of trust assets to the children while dad is still alive. So maybe dad's thinking, I've got a little comfort by transferring my assets to this irrevocable trust. I know I can never have access to the principal, but I also know the trust instrument provides that the trustee, my oldest son, can make distributions to the beneficiaries. And then hopefully, if I need that money back, my kids who received distributions from this trust will voluntarily, on their own, willingly give those assets back to dad if dad needs to go spend them on something. Now they wouldn't do that because that just parks assets back in dad's estate. They would only do that if dad had an expenditure that needed to be taken care of and dad had no other available assets to take care of that. So there's a lot of maneuvering around by using these irrevocable trusts. The transfer rule is the same, whether you just transfer your assets directly to individuals or whether you transfer assets to one of these particular type of irrevocable trusts where you have no access to principal whatsoever. All the transfer rules are the same. And so you've got to kind of make a decision there. If you're going to partake in something like this, which vehicle and which planning strategy is appropriate for you. Okay, so that's a high level kind of 40-minute explanation of Medicaid planning. I'm going to hit the chat, and we're gonna. I don't know whether to look forward to looking at the chat questions, but I'm up for the challenge. But the bottom line here is what I always kind of preface these conversations with is Medicaid planning is not for everyone. And so I gave some reasons earlier in the live stream why it's not for everyone. Medicaid planning typically does involve getting assets out of your name, starting the 5-year look back period, and then waiting out the look back period so that after that 5 years is up, if 5 years is the applicable look back period, you'll be eligible for Medicaid, or at least those assets that have been transferred will not be countable resources of yours. So, and then you can have, you can make those transfers to individuals or trusts. When you make them to trusts, it's usually some type of control factor that you want. And it's also some tax reason. You want that trust to be what's called a grantor trust, so that you're still paying individually the tax on the trust income. And you, quite frankly, even though you want those assets out of your name for Medicaid and nursing home purposes, you want the trust to be arranged so those assets are still in your estate for estate tax purposes. Yes, the multi-million-dollar exemption will shield those assets from estate tax, but you want them in your estate in order so that your survivors can take advantage of the step up in basis. Okay, so with that being said, let's jump to the chat. Now's the time for you to throw your questions, comments, experiences in the chat. So again, thanks, Janet D. $16,000 in Connecticut from experience. Medicaid care is very bad. All things we've been talking about. Thanks for the input, Chuck Burkett. As Stuart, kids living at home and will be hurt by parents losing the house. Okay, so yeah, there you go. I talked earlier about how Medicaid planning might be appropriate for a family with modest assets and income. And if the parents lose those assets through long-term care costs, one or more of the children might find themselves homeless. So I could see that family kind of wanting to do what they needed to do because there's a pretty significant loss if the assets are lost. All right. Thanks, Paul, for getting all of your value out to the people so that for a better tomorrow. Well, you're welcome, Rand Wolf. We got a lot more to come. Let's see. LD Medicare level facilities in California, absolutely horrible. My mom was in an excellent facility here in Bakersfield in her last years. Costs were just under $8,500 a month. That was 11 years ago. So, yep. We just don't. Yeah. Obviously, those costs, those expenses have gone up. And yeah, LD, you're saying everything that is consistent with what we're thinking. Jimbo B, long-term care insurance that covers assisted living, not in a nursing home. So yeah, let me back up for a minute. Great comment, Jimbo. There probably there does need to be more emphasis on not only retirement planning, huge emphasis on retirement planning with investment advisors, financial planning. Am I going to have enough retirement income? Is my house going to be paid off? Can I meet my expenses when I retire? Can I retire now? Is Social Security going to cover me? But in my view, there should probably be more emphasis in the long-term care expense planning. We see in Connecticut that nursing home monthly cost is $16,000. So that's often not factored into the retirement planning. In fact, most of the retirement planning and retirement income planning that I see, a lot of the calculations are based on the fact that someone's expenses may be reduced in later years because they're not going to travel as much. But that's the opposite of how long-term care expenses could hit you. So the long-term care insurance market is changing. I think they got hammered a while back when they issued kind of the traditional policies, and some of them provided for unlimited care for an unlimited period of time. And so that model has changed, but certainly planning in advance while you're working so that you have the funds to get the kind of care you need and deserve. Great idea. Gotti Fields, what about spousal refusal? Okay, I think maybe what you're getting at is, I will say, sometimes one spouse dies and they leave assets to the surviving spouse, and the surviving spouse wants to refuse those assets. I don't know if this is what you're getting at, Kathy Fields, but the way Medicaid looks at it, if you exercise one of these refusals or disclaimers, it's as if you received the asset for Medicaid purposes and gave it away. So sometimes when people want to say, I don't want this inheritance from my spouse, I'm going to refuse it. Sure, it never does go through your estate, but for Medicaid eligibility purposes, it is deemed that you received it and then gave it away, triggering another 5-year look-back period. I will say that married couples, and done this quite a bit in the right circumstances. You might have one spouse who's in the nursing home or is starting to get dementia, and you feel like, or maybe severe rheumatoid arthritis, where they have one of those conditions that makes them likely to need long-term care in the future. It may not be cancer, may not be a heart condition, which doesn't necessarily mean they'll be in long-term care. But oftentimes when we set up that couple's estate plan, we're like, okay, the spouse who's not likely to need this care in the future, let's make sure if they die first, their assets don't go to that spouse who will need the care. Let's make sure when that first spouse dies, if it's the community spouse, let's make sure their assets go to the children, for example, instead of lumping those assets into the estate of the spouse who's going to need care, and then it all has to be spent. Okay, Paul, what about Valerie? Paul, what about a single mom who owns a modest home and is caring for a 20-year-old on SSI for a TBI? Can Medicare attach a lien on the daughter? Yeah, there are some exceptions where you can leave your home, transfer a home to a child with certain conditions, and that's okay. Give your home. So you would just have to look at those particular circumstances and see if you fit under one of these exceptions. Can you do a trust and leave everything in my daughter's name? Not really sure what you're getting at. Usually when you do a trust, your daughter is the ultimate beneficiary of that trust to receive the assets when you die, or to receive the assets when the trustee distributes the assets to them. Not really sure what you're getting at. Paul, regarding the ethics issue, you are kindly explaining the current nature of the existing law. Paul, people can call their legislators to complain who they foolishly voted into office to begin with, and smiley face emoji after that. So good. Yeah, the government really, by having the legislation the way it is, they're encouraging people to transfer assets out of their name, transfer millions of dollars of assets out of their name in order to get these government benefits. So if the government doesn't want to encourage people to do that, perhaps the government should change the rules. Maybe there are significant limits on how much can be transferred. Maybe the look back period goes from 5 years to 7 years or 10 years or 15 years or 20 years to keep these people who have the means to enable them to cover their own expenses. So tough argument there, tough issue. Isn't the look back period 3 years in California? Yes. Valerie, good point there. Thank you for all. You're welcome. Kikizozu. C Sparks in New Jersey, 5-year look starts at first application, so don't apply at all until 5 years have passed. Future applications don't change the story. Yeah. So we mentioned that earlier. C Sparks, you really don't want to apply until you know that you're going to qualify. If you make a big transfer and then you apply, 4 years and 10 months after that transfer, don't do that. Just wait the 2 extra months and then apply. If you apply 4 years and 10 months into the look back period, you're going to be subject to a penalty period that is much longer than the original 5-year period. I know that's a mouthful, but I think bottom line here is you don't want to apply until you know you'll qualify. LD, I have long-term coverage on both myself and my wife in case we need it. If we don't need it, it was a good investment to protect the estate. Yep. So a lot of these kind of combo long-term care life insurance policies, at worst, you're going to get your money back through the life insurance component. And at best, it's going to cover your long-term care expenses far more than you put into it. So LB, what about factoring in veterans? This is not really a veterans benefits. That's a different program. I appreciate the question, but I'm going to pass on the VA or veterans benefits because there's different rules there. Judy Miller, I just went through all this over the past 7 years with my mother, and everything you were saying is spot on. Ooh, good to hear, Judy. Thank you for that confirmation. I could have saved a lot of legal fees if I'd heard this 7 years ago. Laugh out loud. Glad you're able to LOL. Johnny 5, what if the primary home value is over? Does this mean you would not qualify ever? I suppose it means that person's going to need to sell their $1 million home, and then they're going to have to buy perhaps a home valued at less, and then they're going to have to figure out how to protect those proceeds or something like that. So, they won't qualify if they just walk into the Medicaid office and say, "Hey, I've got a $2 million home." Just going to get denied. So you got to do something about it and transfer it out. Wait the 5 years, sell it, buy a lesser expensive one, but then you're dealing with cash now that you've got to deal with. So not an easy issue. Okay, that we survived this, and so you guys were a great audience, some great chats, some great questions. I'm going to do some more YouTube live streams next week. Haven't posted them yet. I'm going to work on that this weekend. If you have some topics, I've got a list of about 50, but more than happy to hear of some estate planning related topics that you'd be of interest to, and others would as well. So y'all have a fantastic weekend. Happy New Year. Looking forward to working with you more in 2024. Have a great day. See ya.